Three things that you should know as an employer or employee of a foreign national. So if you are a foreign national employee or really person in the United States, or if you employ foreign nationals in the United States, today we are talking about three things that you should know about international travel and returning to the United States. Welcome to Live at Lunch. My name is Emily Sumner with Sumner Immigration Law, and I'm so glad that you are joining us, whether you're joining us live or catching the replay. As always, this information is for educational and informational purposes only, and it is not legal advice. Every case is different, so absolutely talk to your immigration lawyer before you take action. So what are three things that you should know or consider think about before you plan on traveling internationally and re-entering the United States? Number one is know the documents that you will need to re-enter the United States. Just because you are in the United States right now in a valid immigration status does not mean that you are automatically permitted to leave the United States and re-enter. There are going to be certain documents that you need to be able to re-enter the United States or to apply for admission to re-enter the United States that may or may not be the same documents that you used to enter last time, depending on your immigration history, whether you've changed status, that type of thing. Generally speaking, you are going to need a valid passport. There are exceptions to that, of course, but you're going to need a valid passport. And look at the validity of your passport. In general, your passport needs to be valid for at least 6 months beyond the date that you intend to return to the United States. Further, when you re-enter the United States, make sure to check your I-94. If you're here on a temporary visa classification, check your I-94 to make sure that they have admitted you that on the I-94, the record that shows how long you're able to stay in the United States, it has your correct spelling of your name, your date of birth, the correct visa classification, and the correct expiration date. I can't tell you how many times over the years we've had clients who have had their expiration date, their validity date of their I-94 shortened to match their passport validity, which is by law what's supposed to happen. It's not wrong. So make sure that you double check that when you enter the US and make sure that your passport is valid for long enough when you enter the United States. Depending on your immigration situation in the United States, you may need a valid visa to be able to re-enter the United States. Again, check the visa. Some visas are valid only for one entry. Some are valid for multiple entries. They have different durations that may or may not match the actual duration of your underlying status here in the United States. So make sure that you're aware of that. If you are in a situation where you need a travel document, such as an advance parole document, make sure that that's valid. I know it sounds silly, but make sure that it's valid and that you have it before you leave the United States. If you are here in the United States with a green card and you have a green card renewal and process, or you have applied for naturalization, or more importantly, you have the I-751 petition to remove the conditions pending, that's for marriage-based green card process, make sure that you have the proper documentation. In general, that's going to be the green card, the expired green card, and the receipt notice. So make sure that you have that documentation. Again, this is not legal advice and every situation is different. So make sure that you talk to your immigration lawyer ideally before you make those travel plans. An example of when things have gone wrong for clients over the years, or people who've come to me, they're not clients yet, but have come to me, is one is assuming that a valid work permit or the employment authorization document is valid for travel. I had a situation where a client had originally a combo card, so it was valid for travel and work authorization. He had to renew it, and then subsequently only the EAD was approved. The travel document was not approved yet. He didn't know that, didn't realize that, and traveled, didn't have a valid advance parole document. So make sure that you're looking at the documents and that you have a clear understanding of what you will need and what documents will allow you to apply for admission to re-enter the United States. In addition, check the visa validity and the petition validity. If you're here in a non-immigrant status, those don't always match up. Sometimes they do, but not always. So you may have a valid petition, but not have a valid visa, or vice versa. You had to have a visa that's valid, and your petition validity could not match that. So make sure that you take a look at that. Point number two, understand the risks of travel. I would love to say, oh, you're here in the United States. Yes, you absolutely can travel and come back in, no problem. That is not the situation. It has never been the situation, really, unless you're a US citizen, but especially in this environment, it is not the situation. When you leave the United States, if you have the proper documentation, you can apply for readmission to the United States. But when I say apply for readmission, it's discretionary, and there may be reasons that you're not allowed to re-enter the United States. Generally speaking, and I don't say that to scare anyone, but generally speaking, clients re-enter, knock on wood, literally, they re-enter without a problem, but you have to prepare and plan ahead of time and know the risk that you're taking, however small that risk might be. So what are those risks? It can include things like if you have to apply for a visa, you're probably going to have to, you will have to have an interview. The Dropbox application process is no longer a thing. You're going to have an interview. You may or may not have a delay in scheduling the interview. When you have the interview, hopefully everything goes well and you get your visa back within a week or two of entering the United States. However, that's not always, or within a week or two after applying for the visa, but that's not always the case. We're seeing an increase in 221G notices, which is a notice from the Department of State, from the consulate, that says that they have to look at your visa and apply, or look at your application, and they may request additional information. They may do additional background checks, all kinds of reasons for potential delays. So know that that is a possibility and build in buffer time. If you are an employee or if you're an employer, make sure that you're, to the extent possible, and I know it's difficult, but allow for this buffer time, allow for the possibility that that employee may not be able to return to work as quickly as you once anticipated. In addition, just because you have the quote correct documentation to enter the United States does not mean you're automatically going to be admitted. And again, I don't say that to scare anyone, but it is, you know, if you have, for example, an advanced parole document, it says on the advanced parole document that this document allows you to apply for readmission to the United States, but it's not a guarantee that you'll be let back in. So just know that there is an element of risk anytime that you travel. And the third point is know how the travel that you are contemplating, that you're thinking about, may impact your current immigration processes. So they're all different things to consider here. One of the top ones is, do you have the green card process going on? And if so, are you in a visa classification that will allow you to leave the United States and re-enter without interrupting the green card process? And you're in a visa classification that would allow you to re-enter even though you have the green card process going on. So that concept is called dual intent, and we have a video about it in our Summer School Business Immigration Basics series on YouTube. So check that out if you're interested. But know that if you have the green card process going on, and it depends on where you are in the green card process, which green card process you're going through, there are a number of factors, but basically if you have submitted it's not limited to this, but if you have submitted the I-485, you absolutely have to be very careful and strategic about leaving the United States, making sure that you have permission, that you have the proper documentation. If you have an advanced parole document, then generally speaking, yes, that would allow you to leave the United States without abandoning your green card process. If you don't have that document yet, you may not be able to travel. Again, it depends on your visa classification. It's complicated, so talk to your immigration lawyer, but know that that is absolutely one of the things that you need to consider, regardless of where you are in the green card process and regardless of the type of green card process that you're going through. In addition, if you have a pending change of status request, so if you are in the United States and one visa classification and you have filed an application to change to a different visa classification, let's say, for example, just making this up, you entered on B1, B2, a visitor visa, and you filed a change of status to F1. If you leave the United States while that application is in process, it will be deemed abandoned and denied. That may be okay with you, but you really should know that ahead of time. You've got to know that ahead of time so that you can have a plan for re-entering the United States, have the proper visa to re-enter the United States, that type of thing. In addition, if you're in the process of changing employers, whether you're on H-1B or TN or E3, whatever the visa classification is, make sure that you're having a conversation with the immigration lawyer handling that paperwork so that they know what your travel plans are and that you can make a plan accordingly and have a very strategic and intentional plan that will allow you to re-enter the United States and not interrupt that process. So a simple rule of thumb here overall is talk to your lawyer, talk to your employer if you are an employee, talk to your employee if you're an employer, have these conversations ahead of time so you know what to expect. We as immigration lawyers are here to help. We absolutely want you to be able to travel and reduce that risk as much as possible, but we can only do that if we know that you're traveling. So make sure that you tell your immigration lawyer ahead of time, as far ahead of time as possible, not like the night before, but as far ahead of time as possible that you're traveling so that we can help you come up with a strategic plan. If you need assistance with a family-based or immigration or employment-based immigration matter, whether you are an employer or an employee, a individual, a family, we are here to help. My name is Emily Sumner with Sumner Immigration Law, and we help clients with this type of case around the country and around the world all the time. We would love to help you next, and we will have an outro slide following this with information on how to contact us. We would love to hear from you. If you have questions, please put those in the comments. I'm happy to help. I can't give legal advice in this particular form, but I'm happy to answer general questions if I can. Otherwise, I hope that if you found this video helpful, you will subscribe to this channel and like this video and share it with a family member or friend who might find it helpful. Otherwise, I hope you will join us next Tuesday for our Live at Lunch Tuesday at noon. Until then, my name is Emily Sumner.